Good evening, everybody. We are delighted to have the distinguished professor of political science, Dr. Frank Baumgartner, with us. He's at the University of North Carolina at Chapel Hill. Welcome, Dr. Baumgartner.
Thanks so much for having me.
Your book was published in 2018, and since then there have been a few positive changes and a few negative changes. I'm thinking California, Colorado and Virginia have joined the ranks of those states that have abolished the death penalty. And some states have gone back to the firing squad and nitrogen gas as a means of execution. But I wanted to start out by talking about Furman v. Georgia, which you start the book off with. I was surprised to find that it was not a unanimous decision. And I'd like to get your take on the differences among the justices as to how they came to abolish the death penalty.
Yeah, that's a great question. I mean, I think many of us who are not attorneys or scholars of legal history think about Brown v. Board and the um, actions of the court at that time. They knew that that was such a controversial decision to integrate the schools that they worked together to come up with something that could be unanimous because they knew that it had to be a really strong opinion. In Furman v. Georgia, that was not the case at all. It was a 5-4 decision, and it was equally monumental. Perhaps it didn't affect as many people. There were 600 people on death row across the country at the time, roughly speaking. So it's not as monumental as the Brown v. Board decision in 1954, but in 1972, they knew that this was a very important decision, and they could not come together. Even the majority came together 5-4, but they did not sign the same majority opinion. There were several different opinions concurring with the majority, so, and they came up with different reasons for abolishing the death penalty. There were two justices who said it's unconstitutional under any circumstance. By definition, it's cruel and unusual. Others said, well, it's freakish and wanton. That is, it makes no sense. It's like being struck by lightning. That was Justice Brennan. And he also said, and if there is any logic to it, it's the unacceptable logic of race. But we can't find that, so we set it aside. But he still ruled the death penalty unconstitutional because it was capricious.
Mhm.
Out of a large number of potentially eligible homicide offenders, just a few were selected, and it didn't make sense who was selected and who was not. That's still the case, by the way. Anyway, it ended up being only a 5-4 decision, and the four justices in the minority were furious. And they laid out a roadmap in their dissenting opinions that the states immediately adopted. They said, well, you have to have a system to clarify who's eligible, and then you have to have a system to clarify that it will be reserved for the worst of the worst. Some kind of proportionality assessment has to be involved. And so the states went to work immediately. And the state of Florida um, enacted a new death penalty statute that they hoped would comply with the new requirements in Furman before the end of 1972. And so that was within 6 months. And then many, many other states came back in 73, 74, 75. So it was quite the monumental decision, but by no means a consensus whatsoever.
So there was a huge backlash among the states as a result of the Furman decision.
An incredible backlash, and particularly in the South, more so than previous decisions. And, it came on the heels of a number of decisions in the 1950s and 60s, the Miranda decision, Brown v. Board, and it was only 2 years before Roe v. Wade. So there were a number of Southern politicians who were very upset with the proactive stance of the court, and particularly in Miranda and some other decisions that had to do with criminal justice, the rights of the accused. And then, of course, Brown v. Board was monumental in setting the tone for Southern states' animosity towards the court. So there were signs all throughout the South to impeach the Chief Justice, and it led to a dramatic change in American politics. It's also interesting to think, and David Garland makes this point, that if the United States were a centralized country rather than a federal system, that is, we didn't have states, and the criminal justice system were a national criminal justice system rather than a state function, we probably wouldn't have the death penalty.
Wow.
Because a lot of the response to the 1972 decision was animosity towards the role of the federal government in telling the states how to operate their criminal justice systems and whether or not they could have a death penalty system. And whether you believe that that was a sincere argument or not, it was definitely part of the calculation.
Mm, yeah. And you pointed out also that the death penalty explicitly references the death penalty in the Fifth and 14th Amendments. So it can't be said to be inherently unconstitutional. How do opponents of the death penalty respond to that?
People who support the death penalty say, well, it's laid out right in the Constitution. It's mentioned several times. That is, you can't be deprived of life or liberty without due process. So that means that with due process, you may be deprived of your life. So it's definitely in the Constitution in black and white. On the other side of the ledger is evolving standards of decency. And at the time of the crafting of the Constitution and the Bill of Rights, many things that we don't accept anymore were acceptable constitutionally and socially. The physical punishments were acceptable and expected. Children could be subject to extreme punishments that we no longer allow today. We didn't invent the prison until 100 years after the founding of the country, almost 100 years, not quite. So punishments consisted of being held in jail until your trial, and then after your trial, there were no incarceration facilities for long-term incarceration. So you would have a physical punishment, such as the stocks, an emotional punishment, such as being embarrassed. You could be by the stocks or something like that, the pillory, or you could be banished from your community, or you could be physically punished by death or by some lesser physical punishment. We don't do that anymore. Punishments consist of being deprived of your liberty, being put in an incarceration facility, but we didn't have any prisons. So the original intent argument goes back to a time that is quite foreign to Americans today. But still, I don't want to diminish the importance of that argument because, of course, original intent is a very powerful legal concept these days.
Well, what happened with the death penalty after Furman was decided?
There was a resurgence. I think 35 states, roughly, almost every state that previously had the death penalty, but not all. Most of them came back with a new death penalty statute. Two of them were ruled unconstitutional. In North Carolina and Louisiana, the statute that they adopted in response to Furman was mandatory death sentencing for people convicted of capital crimes. No discretion whatsoever. And their response to Furman was, okay, if you think that our discretion is being used in a racially biased manner or is capricious, we just will take away the discretion and we'll have mandatory death for eligible crimes. And so that was ruled unconstitutional in Roberts v. Louisiana and Woodson v. North Carolina in 1976. And in 1976, we got the modern system, which was basically that there had to be two parts to the trial. The penalty, the phase in which the person is either found guilty or not guilty of the crime, and then a separate part where we weigh the mitigating factors and the aggravating factors, and that's the penalty phase. And then once that was established, and the Georgia and the Texas systems were validated and accepted by the courts, and they're quite different systems, then the death penalty was off and running. And we had a huge resurgence in death sentencing, but mostly in southern states. Pennsylvania,
Former state.
mostly in
Go
southern
ahead.
states in the modern time, and a resurgence in its use through the 1980s until about the mid to late 1990s. And since then, we've had a dramatic and consistent long-term decline that's been going on now for 25 years.
And I guess that's the result of the Gregg v. Georgia decision. These new policies came into play.
The 1976 validation of the Georgia system and the Texas system opened the floodgates to other states to mimic or copy those laws, and then to begin up their death penalty systems again. Florida and North Carolina, with their mandatory systems, anyone sentenced under that system was commuted. And then they had to rewrite their laws. And for example, in North Carolina, the law was mandatory prosecution, but the jury has the freedom to use their discretion not to sentence to death. And that went on until 2001. Only in 2001 did prosecutors get the discretion not to seek death, which was the case in every other state. So the states have a quite wide variety, a lot of latitude in how they want to design their systems. And the systems were very, very active in the 80s and 90s. So one of the biggest predictors of having a death sentence is, did you commit your crime in the 80s or 90s? That same crime in 2010, 2015, 2020 has 1/5 the chance of leading to a death sentence, statistically speaking.
Would it be fair to say that in Gregg v. Georgia, they basically adopted the dissent in Furman?
Almost verbatim. That is the dissents, the various dissents. There were 4 different dissents. There were 9 opinions. No one could agree with anybody else on the court. There were 9 opinions issued. I've never seen another case like that. And the dissenting opinions, which included the Chief Justice, pretty much laid out the roadmap for how a state could design a system that would be constitutional according to that same court. Of course, they had to get a 5th person to agree with them, and they got that in 1976. I should also say, though, that I don't think the justices realized the monumental reaction that the Furman decision would have. President Nixon, Richard Nixon, was president of the United States at the time, and there was a surprisingly strong reaction to Furman, especially in the southern states, and it mobilized the Republican Party in the southern states also. And so it started to become more of a partisan issue than it had been in the past.
I think you mentioned that they saw this as an attack on Southern values.
Traditional Southern way of life.
Yeah, what
Now,
does
I
that?
should say that in the North, in Massachusetts, and in New York, and in Pennsylvania, historically, the death penalty had been widely used. Many times, historically, before, say, 1900, in the 19th century and the 18th century, it was widely used for crimes of morality, adultery, and other crimes that we wouldn't consider for the death penalty today were widely used in Massachusetts, New York, and Pennsylvania, and not so much in the South. But since 1976, death sentencing has been much more concentrated in the southern states. Now, Illinois and Pennsylvania and California are counterexamples to that, but New York and Massachusetts are northern states that were prolific users of the death penalty in historic periods and faded away almost completely in the modern times.
A lot
So
of
it
them,
became a southern phenomenon.
a lot of the northern states seem to have abolished the death penalty. In New England, of course, and Michigan.
Michigan never had the death penalty as a state, and yeah, the northern plains, Minnesota, Wisconsin don't have it. And then beginning around 2000, I could give you the exact dates. In 2007, New York and New Jersey abolished, and since 2007, there's been a number of states, 15 states have abolished or have a governor's moratorium on execution. So they may continue to sentence some people to death, but they won't carry out the executions. And that includes Pennsylvania, as well as Oregon and California. And California is a big death penalty state,
Yeah.
just like Pennsylvania.
You mentioned proportionality. Apparently, that's been lost in the shuffle. Is that still
Um,
applied by various courts?
there's a mandate. This court issued a mandate in Gregg that you have to have some kind of system to assure that your death penalty statute, as applied, is reserved for the people who commit the most heinous crimes. So they mandated that there should be some kind of Supreme Court automatic review by the state Supreme Court, and that those appellate reviews should assess whether the death penalty was appropriate. Because you think, I mean, there is a logical concern here that is, if you're a member of a jury, you're faced with one case and you're given evidence about the particular facts in the case in front of you, but you don't have any opportunity to compare that case to other cases because you're on the jury only for a single case. So there is a logical possibility of some kind of lack of consistency from one jury to the next. So the court ruled, and it made sense, that there should be a review by the state Supreme Court that would do that type of comparative analysis. The problem is that it never worked effectively. It never worked very well. State Supreme Court proportionality reviews tend to be very cursory, and it tends to be the kind of thing where they look for any other person previously sentenced to death whose crime was roughly similar to the one in front of them, the one being considered. So it's not the kind of proportionality review that I would do as a social scientist, because that would have to involve every death eligible homicide and an evaluation of which ones got death and which ones did not get death. And it would be quite a large scale review. The state of New Jersey actually hired as a special master a law professor named David Baldus to do their proportionality reviews. And after that, they never sustained a single death sentence because he did it. He really paid attention to, was this proportional? And was it the, most heinous crime? Or was it a run-of-the-mill, and it's hard to talk about homicides and break them into categories of garden variety versus heinous, because somebody's child was lost in every one of these homicides. So I want to be clear that that's a very difficult process, a very difficult thing to even think about. But that's what the law demands. The law demands that the death penalty be reserved for, quote unquote, the most heinous or the most deserving offenders who committed the most heinous, egregious crimes. So you might imagine there could be some ways to think about that. Did they torture the victim, or were there multiple victims rather than just one victim, or was the victim a defenseless child, or something that you could think of? But we've never come up with an objective list of what would be the factors that should lead to death. So it's quite left up to the discretion of the jury. And of course, juries make different decisions in different cases, and the juries don't have any information about other cases. They only look at one case at a time. So I would say proportionality review has been a monumental failure. There's almost no consistency. And there's many, many people who commit terrible crimes who avoid the death penalty. And there's many, many people who commit what most of us would consider relatively common crimes, such as a convenience store robbery or a bank robbery or some other kind of robbery. And in the spur of the moment, they get nervous and they pull the trigger, unfortunately. And those are terrible crimes. Somebody dies. But it's not like they're even premeditated, other than the underlying robbery, which might very well be premeditated.
Greg also ushered in aggravating and mitigating factors, and you mentioned it as a whole new industry grew up after that. Um, how does that work in the death penalty system?
Well, the funny thing about it is the states have to enumerate the aggravating factors. So an aggravating factor might be that and it differs, of course, state by state because that's how our legal system works. But an aggravating factor might be that the crime was committed, the murder was committed during the commission of another felony, such as a robbery. That would be an aggravating factor. Or that there was a simultaneous kidnapping or sexual assault or torture of the victim. That would definitely be serious aggravating factors. Or that the victim was a police officer. Might be a legal aggravating factor. And then the mitigating, and the states have to list and enumerate the aggravating factors. They have to be written down in black and white. The mitigating factors, though, can be anything. And they can be enumerated by the states. And it might be that the person was of youthful age, or that the person was only a minor participant in the crime. That is, they weren't the trigger person. Somebody else pulled the trigger, or that they were along for the ride and there was somebody else who was the mastermind of the crime who has more culpability than the person in front of us. So they can list out the mitigating factors, also the intellectual capacity, the emotional state of the person, whether or not they were high on drugs, which of course many people are intoxicated at the time of a crime. So they can be listed. But the Supreme Court also ruled quite emphatically that the list can never be complete and that the jury is welcome to consider any other factor that they may think of. So that seems to tip the scales towards the mitigators. On the other hand, when you look empirically at how many aggravators are presented to the jury and how many mitigators, it really doesn't matter how many mitigators are presented. The death sentence is more common and likely when there's a lot of aggravators. Mitigators don't count as much.
Greg also ushered in bifurcated trials. Could you explain what that means to the death penalty system?
Yes, in the previous historical period before Furman, there would simply be a trial and then a punishment. And one of the requirements of Furman, and then enacted in Gregg, was that there be two parts to the trial. The first part determines whether or not the person is guilty of the crime, and also whether they're found guilty of capital murder, because in a capital prosecution, it could be that the jury would say, well, they're guilty of murder, but it wasn't premeditated, and therefore it's second-degree murder or potentially it's manslaughter. So they have to be found guilty of capital murder first in the guilt phase of the trial. If they're found guilty of capital murder, then the same jury, the same judge, the same attorneys move immediately, perhaps the next day, but sometimes the same day, to the penalty phase of the trial. And at the penalty phase of the trial, there's only one question on the table. Should the penalty for this crime be death, or should it be life without the possibility of parole? Or back in the 1970s, sometimes the alternate punishment was life with parole. In that stage of the trial, the penalty phase, evidence might be presented about the prosecution might present evidence about the various aggravating factors, the suffering of the victim, for example, or the premeditation, planning on the part of the offender. And the defense might present evidence about the person's childhood, their emotional state, their level of intellectual capacity, their intoxication, and literally anything else that they choose, because there are no limits on what mitigating factors might be considered by the jury.
According to Stephen Bright, poor lawyering is a major cause of death sentences. You agree?
Absolutely. When we look in the death sentencing system, it's poor people. It's poor people, and many times they have poorly trained lawyers. I think one of the biggest questions, one of the biggest changes in the death penalty system since the 1970s, when the modern system was established, was a very difficult process of mandating higher quality attorneys at the trial stage. And many, many people have been sentenced to death, especially in the 70s, 80s, and 90s, and especially in the southern states, where the attorney who represented them had no particular expertise in the complex details of capital trials, and who may have been paid a flat fee. In North Carolina, the fee was $5,000 to defend somebody for a capital crime. And then the defense attorney, who would be appointed by the court, could be anybody with a valid bar license. So not necessarily a specialist in the complexities of capital trials. And also, if they wanted to recruit an expert witness, a forensics expert, or a doctor, or another type of forensic expert to give testimony, they would have to ask the judge for permission to increase the budget to pay that expert for their time. That went on until about 2001. And at that point, there was a reform that mandated that there be a qualified person with training in capital punishment and capital defense litigation, and also that there be two attorneys in a team with at least one mitigation expert and perhaps a social worker. So there was a dramatic increase in the quality of defense that came later, but that was 2001. Many, many people, hundreds of people in the 1980s and 90s had previously been sentenced to death with questionable levels of legal representation. So there was a struggle throughout the states, especially in the South, to improve the quality of that legal representation at trial. But I would say it's an embarrassment to the country to think about the level of legal representation and concern for having top quality legal representation and the amount of financial resources that went in to providing that type of legal representation to the accused compared to the resources that were available to the prosecutor.
Yeah, that's been a problem in Pennsylvania. Only until very recently did the Commonwealth only did not provide indigent defense money statewide. They left it to the counties with very spotty results. I was also surprised.
It's the indigent defense problem is, you think about it from the perspective of a state legislator thinking about how do the taxpayers want me to vote to spend taxpayer money. Indigent defense for capital accused, capital defendants is way down on the list of what the average state legislator probably thinks their constituents really want to have money spent on.
But at the same time, I think the second biggest budget item is prisons in Pennsylvania.
Well, that's different. That's punishing people who have been found guilty of a crime. So politically speaking, it's not that hard to find support to punish people who've been convicted of a crime. But it is hard, and I think this is a national problem to think about, how do we, what is the minimum statutory or constitutional requirement in terms of financial resources available to a person accused of a serious crime? And what do we owe to them as taxpayers? And it turns out it's the political process is not a process that's likely to lead to generous support for indigent defense. It has to come from the courts. There has to be some kind of mandate to force the legislature to do it because it's very politically unpopular to spend massive amounts of money on the defense when at the same time the taxpayer is also supporting the prosecution. So the idea of financial fairness there is causes, I think, the average American to think, well, which side are we on? Are we trying to avoid the punishment or are we trying to impose the punishment? And why do we have to pay for both? So I think there's a problem here. There's definitely a problem here.
I was surprised to learn that in Pennsylvania, there's no cap on the number of cases a lawyer can take. And it seems to me that would tempt lawyers to take more cases than they're reasonably able to handle.
Well, the other part about those financial considerations is that your top attorneys who might be quite financially successful aren't going to bother with these things. The people who are going to take many, many cases are either desperate for work and are going to put in the minimum amount and take the reimbursement or the fee, or they're committed anti-death penalty crusaders who are going to do their best, but who might be very well qualified, and who are never going to turn down a case because they don't want the person to go unrepresented. But still, those people might become overloaded.
Yeah. Let's see. In Pennsylvania, a couple of nonprofits have stepped into the breach, and the Atlantic Center for Capital Representation, also the Abolitionist Law Center. So that I think that's also a factor in why district attorneys aren't pursuing the death penalty as much as they used to.
Bringing resources to the table is really important. And, kudos to those lawyers and the people who found the way to make those organizations function. It's not an easy job. It's not a popular job. And, but it makes a big difference.
Yeah. Can you talk about death qualified juries and how that affects the death penalty?
Well, this is one of the things that surprises newcomers to the death penalty. There's several things that just shock people, but if when you the Supreme Court has ruled that no one can serve on a capital jury if they would be unwilling to impose a sentence of death. And there's a way in which this makes sense because if you get to the penalty phase of the trial and you say, "Oh, I'm sorry, I'm unwilling to consider one of the penalties that's on the table, so automatically I'm going to vote only for the non-death option," then that's not fair to the prosecution. But there was no reason why. I mean, I can't see the reason why when they created the bifurcated trial system, you had to have the same jury for both the trial of guilt and the trial of punishment. It does make sense that a person who is unwilling under any circumstance to impose a sentence of death shouldn't be on the penalty phase. Similarly, a person who would impose death every time, no matter what the circumstances, that person should not be on the penalty phase. But they can't be on the guilt phase either. And so when we impose this rule and we impose it at the guilt stage of the trial, essentially what we're doing is we're cutting off about 25% of the jury pool who are people who are concerned or unwilling to support the death penalty. It includes a lot of Jewish individuals, a lot of Catholics, and a lot of African Americans. And then other people who just by their ideological position could never support the death penalty. But for many people, Quakers, for many people, it comes from a religious stance that their religion teaches them that the death penalty under no circumstance is acceptable. Those people are relieved from their potential jury service. So there is even at the stage of finding whether the person is guilty. So it definitely tips the scales in the direction of guilt, and it raises very serious questions of fairness. When I've looked at statistics on this, of course, it works on both sides of the scale. Someone who would say that they would impose death for any murderer also is not eligible to serve on the jury. But there's about, I think, roughly 5 people excused because they would never impose death for every one person excused because they would always impose death.
You mentioned in your book that juries are whiter, more male, and more favorable to the prosecution as a result of that rule.
Exactly.
Yeah. You also
And
pointed,
there's also particular religious denominations are more or less selected into the system. As I mentioned, if you're Catholic and, or if you're Jewish, or if you're a certain religious perspective, you may have learned in church that you do not support the death penalty. And those people are going to be selected off the juries. So there's serious issues of constitutionality with um, the jury selection.
you also pointed out that the states with the highest rate of execution are not necessarily the states with the highest homicide rates.
No, the correlations, no matter if you look county by county, year by year, state by state, it's like some kind of fairyland. Nothing correlates with anything. The states that have the highest number of homicides don't have the highest number of death sentences. The chances of having that death sentence carried out differs dramatically from state to state. For example, Pennsylvania is a very prolific death sentencing state, but has executed only 3 individuals since 1976. California is like Pennsylvania, very, very few executions, just 13. But they have sentenced over 1,100 people to death. Compare that to Texas, where they have about 1,100 people sentenced to death since the 1970s, but they've actually executed almost 600 of them. So if you're going to get sentenced to death, it's better to be sentenced to death in California or Pennsylvania rather than Texas or Virginia, which during the time when it had a death sentencing system, it carried out 70% of all the people sentenced were executed. So the capriciousness, the arbitrariness, the random factors of being struck by lightning are with us in every aspect of the death penalty system. That's one of the most shocking elements of the system. It's not like clockwork. It's the opposite. It's just being struck by lightning.
One of the most surprising things that I read in the book, the most eye-opening thing, was, quote, the vast majority of death sentences have been overturned.
Yeah, 70%.
I,
It's insane. It really is shocking and it's consistent state to state. The We've had the numbers are tell a story. We've had almost 10,000 death sentences, over 9,000 death sentences since 1972. We've had about 1,600 executions, and there's about 22,000, 2,500 people on death row across the country as of today. So if you subtract those numbers out, there's 7,000 missing people. And they were, roughly speaking, 6,000 maybe. So they were reversed. Their sentences were reversed, or perhaps they died in prison. But for the vast majority, and there's been very detailed studies of this, but about 60 to 70% of all death sentences are the object of a successful appeal, either at the state Supreme Court level or in the federal courts. Now, once they're overturned, often it's the penalty phase that's overturned, not the guilt. But sometimes it might be the guilt that's overturned, and then there'll be a new trial. That's not double jeopardy. If on appeal your sentence is overturned, the judge will order there to be a new trial. And at that new trial, you might be sentenced to death a second time. And then that might be overturned. It also has a 70% likelihood of being overturned. And at your third trial, you might be sentenced to death again. And that has a 70% chance of reversal. So, anyway, at the end of the day, if you're sentenced to death, your conditional probability of being executed across the country is about 15%. In Pennsylvania, it's 0 unless you volunteer. In California, it's about 1%. And in Virginia, it was about 70%. And in Texas, it's about 50%. So the numbers are much lower than you might imagine. And also it's important to think of this. When you're sentenced, if a person is sentenced to death, the judge will intone from the bench, the state of Pennsylvania hereby sentences you to die by lethal injection. May God have mercy on your soul. 3 or 4 or 5, 10, 15, 25 years later, oops, just kidding. You're no longer sentenced to death. Now you're sentenced to some lesser punishment because we found that the judge gave improper instructions to the jury, or that the prosecutor withheld evidence, or that there was some kind of legal flaw that a federal judge finds to be so important that he or she invalidates your death sentence, and mandates a new hearing. So those can't be just trivial little things like a misplaced paperclip. They have to be something that was seriously problematic in that trial. And it brings attention to the idea that these trials are highly emotional affairs. There's a terrible crime at the core of every one of these stories. And somebody passed away. Somebody was brutally murdered in most cases. It's just a question of how brutal was the murder, and do we have the right person in front of us who was responsible for the murder? But there's always a terrible crime. I say that, but I want to correct myself, because sometimes there is no crime. There's a shaken baby. There's some kind of terrible tragedy where a person dies of natural causes, and then somebody is basically framed for that and convicted of killing somebody when in fact the person died of natural causes. But in most cases, there's a terrible crime. There's definitely a death. And if it's a child who passes away, there's a lot of emotion, and people want to find somebody guilty for that. And so we find people cutting corners, and we find that on appeal, the appellant is successful most of the time.
You mentioned that women are often subject to the death penalty when there was no crime. Is that what you mean by the shaken baby?
Yes, and the issue of gender and the death penalty is quite astounding. I mean, as you might imagine, women don't commit very many homicides. And even when women do commit homicides, which is only about 10% of all the homicides in the country, they still represent only about 1% of people on death row. Even females who commit a homicide are very unlikely compared to males to be subject to a death penalty. But if they are, it tends to be for a family crime. killing a child or perhaps a partner. Whereas for men, that crime is less likely to lead to a death sentence. And since it's a child, many times it's an infant. And when there are cases where infants are killed, there's been many, when infants die, I should say, there have been many findings of improper forensic evidence suggesting a homicide when in fact there was only a natural death or a birth defect. So women are more likely to be subject to those wrongful convictions, especially in the death of infants.
And you also talked about the reasons for exonerations. And I was looking at the death penalty information database, and official misconduct seems to be in almost every uh, exoneration. I think we're up to 200 now.
Yeah, we're at 200 exonerations, and we've had, so that's more than one exoneration for every 10 executions. So it should give people pause. And, if that were NASA sending up space shuttles or, the Postal Service delivering the mail, and there was an error rate of 1 in 10, people would be outraged. They would write their congressman, they would write their senator, and they would refuse to pay their taxes. It would be a social upheaval. But this is different. This is the criminal justice system. Most of us don't think of ourselves as anyone who could possibly be involved in such a thing. And errors are rampant. And many of the errors come from overzealous prosecution where people skirt the rules. And I think from the prosecution side, we also have to understand the emotion there that there is an infant who died. And either that infant died by natural causes or his mother killed him. And there's no middle ground there. And so, depending on if you think that you're prosecuting somebody who's guilty of the crime, maybe you want to make sure that they are found guilty and you don't follow every single rule. So, anyway, it is quite common when we find exonerations that the legal justification for the exoneration is some kind of flaw in the prosecution. They didn't hand over exculpatory evidence. They didn't read somebody their Miranda rights. The police interrogation was faulty. The lineup was faulty. There's many ways in which an investigation or a prosecution can go off the rails. And then the prosecutor can decide to halt the case or go forward with it anyway and hope for the best. And so what we're finding is many times they go forward anyway. There's a lot of emotion. And I think we don't know what the defense attorneys are doing. I'm sure they're quite emotional as well. It's a very difficult set of relations.
You also mentioned that the popular conception that exonerated inmates are routinely, quickly, and generously compensated is not correct.
Nothing could be further from the truth. And here we have just a problem where when somebody does get $43 million in payout from a city or a county or a sheriff's department or it's always in the news. And it makes us think that, oh my goodness, what a lucky day for that individual. But it's not in the news when somebody has their sentence reversed or they're let out. 200 people have been actually exonerated after being sentenced to death. I'm not sure the numbers, but it's not a high number of those who got compensation. And even when there is compensation, typically it's limited to some amount of money like $50,000 per year. In North Carolina, it's limited to $700,000 total. And I know an individual who's come to my class to speak who served 43 years in prison for a crime he didn't do. and he was awarded $700,000 after he was awarded a pardon of innocence by the governor. That's $700,000 for 43 years. He lost his 20s, his 30s, his 40s, and his 50s. In prison, he got $700,000 as a total payout. Now, you could sue and potentially get a civil suit. And actually, this person did get one. He drives a Rolls Royce right now. But that's not common. That's not the common outcome. It happens occasionally, and when it happens, it's all over the news. But when it doesn't happen, it's not in the news. And so we have a misunderstanding of how that process works.
Yeah, I believe there's no statute in Pennsylvania. I think you have to sue if you want to be compensated.
You have to sue, and there's a famous case from John Thomas, who was a person exonerated in New Orleans, where he sued. His case went all the way, and then the state appealed, and his case went to the U.S. Supreme Court, and Justice Thomas and others said, well, there was malfeasance in the case of Mr. Thomas. However, there was no pattern and practice of malfeasance in general in the office, and therefore he doesn't get compensation. So you win some, you lose some.
I think some people would be surprised to find out that actual innocence is not constitutionally protected. Could you talk about that?
It's shocking, but it's true. You're presumed to be innocent until you're found guilty by a jury of your peers. And then when you're found guilty, you're presumed to be guilty. And so demonstrating your innocence once you're incarcerated and you've been found guilty of the crime, and then you have to demonstrate your innocence. You can't just say, well, I had an alibi, I wasn't there. You have to prove something that might be difficult to prove. So proving your innocence is much more difficult than a person might imagine. But the other part about the law, and again, I'm not an attorney, but this would be my understanding, and someone can correct me if I'm wrong. Once you're found to be guilty, at the appellate level, the question is, did you get a fair trial? And the appeals courts are not going to question the facts that were determined to be true or false by the trier of fact, the original district court, the original jury that reached its verdict in your case, where they saw all the evidence and they reached a certain verdict. And the appeals courts are not going to question whether they made the right decision or not. They are going to question whether they followed the proper procedures in reaching that decision. And so the fact that they reached the wrong decision is not grounds for appeal. You have to have an appeal that has something to do with the instructions that they were given, or an objection that the judge overruled that he should not have overruled, or some procedural flaw has to be found. And the fact that you can demonstrate that new evidence shows that you're innocent may or may not be admissible under the rules of evidence. So you have to be a lawyer to really like this system. And many lawyers don't like it, but it is shocking. So, but it is a case. The fact that you didn't do the crime is not grounds for appeal.
Amazing. You pointed out in the book that methods of execution seem to be getting better, or seem to be progressing from barbarous and inhumane to less violent. But
Well, let me correct you there, because I wouldn't want to be quoted as saying that. What I said in the book is that every generation thinks so.
okay.
When we invented the electric chair, we thought that we were moving, or we told ourselves, or the proponents of the electric chair in 1895 told the rest of us that this would be a miracle, that people will be killed instantaneously within 1/10,000th of a second. They won't even feel it. That's the electric chair. And then later, And this was in contrast to the barbarous methods of hanging and firing squads that were used in the 19th century and previously. And then later we had the gas chamber, and then later we had the lethal injection, and now we've got nitrogen gas. And I think each generation that has proposed these new methods has essentially been a snake oil salesman. They've tried to say that they've invented something that's never been invented before in the past, and that every previous generation was barbarous, but now we've reached a higher level of civilization, and it's always been a hype job.
And the use of nitrogen gas, according to Justice Sotomayor, 7 people have been executed using that in Alabama and Louisiana. Isn't it essentially suffocation?
Essentially, there's a mask over your head and you're deprived of oxygen, and the oxygen is replaced with nitrogen gas, and it takes several minutes for your body to die after you're deprived of oxygen. So I think the simple word for the process is suffocation.
What do you think about life without parole as an alternative to the death penalty?
Well, I mean, my personal opinion about it is one thing, but I would say that the states didn't generally have life without parole until the 80s and 90s. And by the mid 1990s, every state that had a death penalty system had enacted the alternative punishment of life without the possibility of parole at any time. When it's considered from the perspective of capital punishment, that reform dramatically reduced the likelihood of imposing a death sentence, because juries in the past, before that reform, sometimes would say, well, I don't want this person ever out on the streets. And if the option is life with parole after 20 years or death, I'm going to go for death. But if the option is life with no opportunity for parole versus death, then many juries would opt for life without parole. So within the context of the death penalty, life without parole has been an important reform. But life without parole is not limited only to the cases where death is on the table. It's been imposed in tens of thousands of other cases as well.
Yeah.
And we are currently at a stage when we're about to have an explosion of geriatric prisoners throughout all 50 states, because the people that commit homicide tend to be in their mid-20s. And if we had imposed the new punishment of life with no possibility of ever being considered for parole in the 1990s, that was 30 years ago. And so those people who are 25 years old, say 40 years ago, they're 65 now. And 10 years from now, they're going to be 75. And they're still going to be in prison. And they're going to pose no threat to public safety. They're going to need kidney dialysis, and some percentage of them are going to need serious medical attention. And the states are going to be on the hook for that medical attention within the context of their prison systems. And we're just on the cusp of this explosion because of the timing of when these punishments were enacted mostly in the early 90s or mid 80s to mid 90s. So we're about ready to see it, and it might create some big changes. So I think it's important to think the death penalty anchors the system of punishment at the highest level. From the perspective of the death penalty, life without parole seems a lesser punishment. But we have to remember what a serious punishment that is. You'll never leave prison. Even at age 85, if you're senile and confined to a wheelchair, and you pose no physical threat to anybody whatsoever, the state will still be incarcerating you if you've been sentenced to life without the possibility of parole. Whereas if you had life with parole at 20 or 30 years, eventually the parole board, maybe not on the first opportunity, but eventually would most likely release you before your elderly years. So it's had a, life without parole is a whole different topic.
We have a question. We have a couple questions from the chat. I think we have a couple minutes to talk a little longer. Let's see. We have a question about cruelty. What about cruelty, Eighth Amendment? Of how some states are carrying out the actual execution. Why isn't this a new basis of a constitutional challenge?
Well, there have been a number of constitutional challenges, but I mean, when you look at 1,600 executions having taken place in our country since the 1970s, hundreds of them have been terribly botched. I mean, whether it's the electric chair catching fire, sparks going everywhere, people's heads going aflame. Once it's over, it's over. There's no more constitutional question. And then the question is, can the next person be subject to that punishment? And the state says, oh, we can assure you that we're going to handle it properly this time. We've identified the problems that took place in the previous execution that was terribly botched. Or they deny that it was botched in the first place, although the flaming electric chair, I think, was difficult for the state of Florida to claim never happened. It did happen. So they switched methods. They moved to lethal injection. Lethal injection, we don't really know how painful it is because the second drug in the 3-drug protocol paralyzes the person. And the only reason to have that paralytic agent injected into the person who's into the condemned person is so that they can't move. But they can't move their mouth. They can't move their eyes. They can't move at all, any muscle. They're completely paralyzed. So they can't wince. They can't gasp. And the only reason for that is so that it will appear to be peaceful. But we have no idea what's going on. And there's a recent book about what happens with pentobarbital and a massive overdose of it, which is what's given to people in the lethal injection protocol. Essentially, it causes your lungs to explode. And then your lungs take in water and essentially you drown. So even in a lethal injection case that appears to have gone according to protocol, I would say I wouldn't want to have it done to me or a loved one of mine. It sounds gruesome. And then we've seen recently Justice Sotomayor's dissent about the nitrogen gas, saying that that's essentially 4 minutes of suffocating a person. And 4 minutes is a long time. So then the question is, why don't we just go back to hanging or to the firing squad? And those can be botched as well, but the main reason not to go back to the firing squad is that there's blood. It looks violent. And somehow we want to have a system of death sentencing or executing people that appears not to be violent, which is a paradox in itself. It's an act of state violence, and it should be recognized as such. So anyway, why aren't they declared unconstitutional? States fight it. And if you're going to have, and the Supreme Court has basically said, if you're going to have a death penalty system, there has to be a method that's constitutional. So they're not anxious to invalidate these state systems. But the states are in a hard spot because there's nobody except in Texas that has any kind of experience with this. And trained medical professionals are generally not participating, although they used to. And people just don't have experience. So they're relatively untrained and relatively unpracticed individuals carrying out medical procedures. So yeah, what could go wrong? Lots of things could go wrong.
Justice Sotomayor also pointed out that nitrogen gas poses a danger to the employees who are administering it.
Administering it,
Yeah.
which is one of the reasons why they stopped with the gas chambers in the 70s and 80s, because the gas chamber had to be evacuated. Like the gas had to be siphoned out of the room after it had to be ventilated after the person had been put to death. And then somebody had to go in there to remove the body. And, I wouldn't want that assignment.
Yeah.
And it turned out it was quite difficult to ventilate those rooms and to evacuate all of the lethal gas. Um, and who's got experience doing that? It's not like you can go to Lowe's hardware store and say, I need somebody to come install some tile in my kitchen. That's one thing. But I need somebody who knows how to evacuate cyanide gas out of an enclosed room. How big does the fan need to be? And what type of ventilation system do we need? And then what if it gets trapped in the condemned person's clothes or in their hair or within their body? It raises these things raise so many practical considerations that can go wrong, that aren't really constitutional issues, but they can rise to constitutional issues when they lead to cruel and unusual punishments.
And we have one last question. Please explain the concept of racial resentment and its relationship to lynching and the death penalty.
Oh, well, I don't know if you've ever seen a set of questions. The survey researchers throughout the country in political science and sociology and others asked a set of questions, and one of them is the Italians and the Irish had to overcome deep prejudice when they first came to America, and African Americans should just work hard like them and they'll be fine. Or a series of questions that have to do with people's attitudes towards whether African Americans face adversity, unfair adversity, or whether they should consider themselves to be equal under the law and in society. And some people score, when you ask them 4 questions, they always give the answer that is considerate and sympathetic to the African American side. And some people always give the answer that's basically hostile, or suggesting that African Americans deserve an inferior place in our society, or that they've earned it, or they deserve it somehow. And we call those people with high levels of racial resentment. So the lack of empathy for the African American condition. Turns out that is a very strong predictor of many attitudes, racial resentment. And of all the attitudes that a person might have that predicts whether or not you support the death penalty, racial resentment is more powerful in predicting support for the death penalty than almost anything. It's stronger than your liberal conservative ideology. It's stronger than whether or not you're an evangelical Christian. And when we combine it with, are you a male rather than a female? And are you Caucasian? And if we find a Caucasian male who has high levels of racial resentment, we can predict with near certainty, over 90% of the time, we would be correct in predicting that that person is going to support the death penalty. And not only is this true at the individual level, but when we compare, and I wrote a paper about this that was published a couple of years ago, when we compare the aggregate levels of that in surveys from state to state, the states that have the highest levels of racial resentment in their population sentence more people to death. And that controls for their political ideology, whether or not they elect or appoint judges, all kinds of things. And the states that have those high levels of racial resentment are also the states that in historic times had more lynchings. So there's a through line in the death penalty in American history. It connects us back to slavery, it connects us to lynching, and it's a story about race and racial resentment. People with white victims are much more likely to get a death sentence than people with black victims. But African Americans who have a white victim are exponentially more likely to get a death sentence than white people with a white victim, or African Americans with a black victim, which is most killings by African Americans also have African American victims. Those cases are rarely considered for a punishment of death. But when the victim is white, death is much more likely to be on the table, especially if the offender is black. So we can't really talk, we can't, it's not accurate to even have a conversation about the death penalty without taking race and racial attitudes into consideration. So racial resentment is a concept that's used by sociologists and political scientists to understand people's attitudes towards African Americans. And it strongly predicts support for the death penalty.
I have several more questions for you, but I think I'm probably going to get a hook pretty soon. We really appreciate your coming on and talking to us this evening. Thank
Well,
you.
I wish we could talk about flights to the moon or beautiful flowers or something like that, but this is the topic for today, and I know it's a very difficult topic, and I ended on a very difficult note, but it's hard to be light and breezy on this topic, and I want to thank all of your, viewers for their concern about the death penalty. Pennsylvania is a big state. We need people who are working in Pennsylvania to work on the death penalty and show its flaws. So thank you for being here.
And thank you for being here. Thank you so much.
My pleasure.
Thank you to Witness to Innocence for collaborating on this event. Their mission is to empower exonerated death row survivors to be powerful voices in the fight to end the death penalty. And there is a link that you can follow to support their mission. Thank you, everybody.
Thank you. Goodbye.
Bye.